What's up, everybody? Welcome back into an episode of The Lawyer You Know on the boat here. We'll be home soon, but we're not there yet. Still cruising around the Mediterranean, and more Karen Reed information, more Karen Reed, more to add to this saga, to add to the movie and the book. Maybe there's a grand jury leak. A grand juror has allegedly at this point, but we're getting pretty close to it just being all done, locked and loaded, since there is a signed plea deal that should be happening relatively soon. We're going to look at the charges of this grand juror, and we're going to look at the plea deal to try to figure out, does this have to do with Karen Reed's case? And if it does, how big of a deal is it? Is it going to be directly connected to the federal investigation? Is it going to be something that's going to lead to other charges, lead to other defenses? Or is it something that's inconsequential? And how can we try to guess exactly what's going on at this point before we get all the information, which at the end of the video, you know what my answer is going to be. We really don't know until we have more information, but let's see what we can get and what we can gather from the information we do have at this point. Let's get into it. All right, first thing we are going to look at is the information. Okay, we have count one, criminal contempt. And one of the important parts of this we're going to see is that this was filed on July 11th. And the timing is going to be important about what this could possibly mean and what this could possibly be as far as Karen Reed's situation goes. So that's going to be important. I do want to highlight that. We're also going to highlight the plea agreement that's been signed by this defendant. So we're going to see what we can try to figure out based on that timing. But first, let's read what this is all about. From or about August 11th, 2022 through on or about March 4th, 2024 in the District of Massachusetts, the defendant. So the first thing we can understand is just how long this person was a grand juror. What is that? A year and a half? It's less than 2 years, right? August of 24 would have been 2 years for this grand juror. So probably heard about a lot of different cases, a lot of different investigations, a lot of different defendants' names. Probably. We don't know, because that's how it works with a secret grand jury. We're not supposed to know what they talk about, what cases they're hearing, what witnesses they're hearing from, what evidence is being presented to them, what decisions they're making or not making. So this time period is obviously the reason why everybody seems to think, and obviously because it's Massachusetts, this is why everybody seems to think this has something to do with Karen Reed. Jessica M. Leslie is the defendant's name. She knowingly and willingly disobeyed and resisted a lawful order. You know what happens, contempt of court, if you violate a court order, a judge's order. A lawful order, rule, decree, and command of a court of the United States, that is Federal Rule of Criminal Procedure 6E2, and the order and command of the Honorable Indira Talwani, United States District Judge on May 26th, 2022. So basically, that's when she gave the order, but the timing of the charges is from August to March of when she was violating that court order. That and a grand juror must not disclose. So what did they say Jessica Leslie did? That she violated the order to not disclose a matter occurring before the grand jury. When on diverse dates, so that means multiple times is what it sounds like to me, she disclosed information presented to the grand jury to unauthorized individuals. We'll talk about who that could be. To wit, the names of various witnesses appearing before the grand jury. So what did she tell these unauthorized people? The names of witnesses appearing before the grand jury, various witnesses. So not just one witness, not just one name, but various witness names before the grand jury, and the substance of their testimony. This isn't like an and or, maybe she did this, maybe she did that. We know that she talked about witness names and the substance of their testimony, what they talked about, and other evidence presented to the grand jury. So it wasn't just witness statements. That would be bad on its own, Because witness names, we know how that can get witnesses in trouble. Witness intimidation. We know in cases, and we've heard from Karen Reed's case to P. Diddy's case to cases all across the country where witnesses might need protection or are in fear of their life. Some you may feel is legitimate, some you may feel is not from case to case. Regardless, we want to protect those witnesses, especially those before a sealed grand jury. And that's why we need these protections and these laws that keep grand jurors from doing exactly what this grand juror did. So she talked about witness names, witness testimony, and other evidence, all while said information was under seal and not subject to disclosure. All in violation of Title 18 USC Section 401(3). Now, let's go over to the plea agreement. That's not it. Let's try that again. Okay, I'm going to highlight the date for you again here. The charges were filed on July 11th. This plea agreement was filed on July 15th. How did they work this quickly? How were they able to get a deal done this quickly? We'll talk about that as we read through it. The United States Attorney for the District of Massachusetts and your client, Jessica Leslie, the defendant, agree as follows pursuant to Federal Rule of Criminal Procedure 11C1C. A change of plea. As soon as practicable, first off, that means charges were filed, she pled not guilty, which is not unusual. Change of plea. As soon as practicable, the defendant will waive indictment and plead guilty to count 1 of the information, criminal contempt, in violation of 18 USC 401(3). The defendant admits that the defendant committed the crime specified in this count and is in fact guilty. So I don't think this hearing has happened yet for the change of plea. That's why I said we're almost there, saying that yes, she did do it. Still technically allegations. She did sign the bottom of this. So confident in saying that these things actually happened and this crime actually was committed by this person, because in this plea agreement, she agrees to that. What are the penalties she is going to face? The defendant faces the following maximum penalties. Maximum. Incarceration for any term of years, which means she can go to prison for a long time, right? Supervised release for 5 years, a fine of $250,000 unless incarceration is imposed, and a mandatory special assessment of $100. So that's the max. Some pretty serious penalties. And so let me tell you, we're going to hear what plea she has agreed to. But when we talk about maximum penalties like this would be somebody on a grand jury that maybe gives witness name and information to a target, somebody that's under investigation, somebody that they might be indicting, and that person goes and harms those witnesses or tampers with evidence, or it's something that creates a colossal problem for everyone, right? And for justice, potentially. Because if something happens to those witnesses, now they go away. Can they still prosecute somebody they were planning on prosecuting? All sorts of problems can happen, right? Victims don't get justice. So there are levels to this. There are ranges of how bad this can be. It's always bad because we already talked about why it's important that this information stay sealed. While legally everybody believes it's appropriate that it stay sealed, especially in the federal process like this. You can see how this would get to a level where it would be a problem. All right. So let's take a look now. Rule 11C1C plea. In accordance with Rule 11C1C, if the court accepts this plea, the court must include the agreed disposition in the judgment. So they're trying to say, Judge, we've all agreed this is what you need to do if you accept this plea. If the court rejects any part of this plea agreement, the U.S. attorney may void the agreement and or the defendant may withdraw from it. So as long as everybody's good, we're good. If the court does not accept the plea, then you can withdraw. And what happens in a situation like that? The judge says, I'm not inclined to accept this. Do you want to withdraw before we go forward? Or U.S. attorney, do you want to void this agreement because I'm not going to accept it? Usually they'll let the lawyers know what's going on. It's not a hide the ball. It's not a trick. Federal judges don't really want to play that game. So they're giving the defendant the opportunity to withdraw if the judge rejects the plea, but the defendant may not withdraw defendant's plea for any other reason. Should the U.S. attorney void the agreement and or defendant moves to withdraw the defendant's guilty plea, the defendant agrees to waive any defenses based upon the statute of limitations. It's not going to be a problem here, but if it was and you delayed and you did this just to delay it and then violate the statute because you were going to agree to the plea and then you withdrew your plea, you can understand why that would be a problem, but that's just protection in there. The constitutional protection against pre-indictment delay and the Speedy Trial Act for all charges that could have been brought as of the date of this plea agreement. So again, that stuff's not really going to be a big deal in this plea agreement, but it could in others. The parties agree. Here's the sentencing guidelines. The parties agree based on the following calculations. The defendant's total offense level under the guideline is 10. The defendant's base offense level is 14. The defendant's offense level is decreased by 2 because the defendant has accepted responsibility of defendant's crime. So that happens with that reduction because they are saying what I did was wrong. I did do this. I'm going to take responsibility. We've talked about it a lot in other cases where they don't do that. The defense level is also decreased by 2 because the defendant is a 0-point offender, no prior criminal convictions. That makes sense, right? That's not a surprise. Why? Because we know this person was chosen to sit on a federal grand jury. So they probably have a pretty clean background, right? Not anymore. They're going to plead to a federal charge. The defendant understands that the court is not required to follow this calculation. The defendant also understands that the government will object to any reduction in defendant's sentence based on acceptance of responsibility and may be released from the parties' agreed upon disposition in paragraph 5 if A, at sentencing, the defendant, directly or through counsel, indicates that the defendant does not fully accept responsibility for having engaged in the conduct underlying each of the elements of the crime to which the defendant is pleading guilty, or B, by the time of sentencing, the defendant has committed a new federal or state offense or has in any way obstructed justice. So you can understand there what all that means. I think we've been through that before. So you understand as long as everybody says, yeah, I did it, I accept responsibility, and they don't commit any other crimes, we're going to be good with what we have agreed to here. Nothing in this plea agreement affects the U.S. Attorney's obligation to provide the court and the U.S. probation officer with our office with accurate and complete information regarding this case. So what did they agree to? The agreed disposition. The parties agree on the following sentence. So we know it can be multiple years, 5 years of supervised release, $250,000 fine. This defendant got an incarceration for 1 day, deemed served. 1 day in jail, already deemed served. If you get arrested and processed, sometimes it can take enough hours for it to be considered 1 day served. Sometimes it can be overnight. Obviously, that counts for 1 day served. So whatever she has done already, deemed served. So she doesn't have to go back to jail. No fine. So from a lot of years to 1 day, already served. From $250,000 to no fine. From 5 years of supervised release to 2. And then the mandatory special assessment of $100, which the defendant must pay the clerk of court by the date of sentencing. No big deal. But that's mandatory. They can't get rid of that. So basically 2 years of supervised release. Don't commit any other crimes and you'll be fine. Sounds like a sweetheart deal. So what are the 2 most likely reasons for not just a sweetheart deal, but also a quick deal? From July 11th to July 15th, this is what they worked out. First off, it could have nothing to do with Karen Reed. It could have to do with a different case or a different investigation that this person sat on the grand jury for. Or it could have to do with Karen Reed. Also, this could be a scenario or a situation where the defendant did something completely inconsequential. No big deal. She talked to somebody at her house, at her job, told them a witness name. Can you believe it? This is that case. Isn't it crazy? Whether it's Karen Reed or not. Can you believe I'm sitting on this grand jury? Can you believe this person testified? Oh, he was so weird, or she was so great, or I loved her, I hated him. Can you believe they presented this evidence? They have this DNA evidence. They have this video surveillance. I watched with my own eyes this cop do this, or this lady do that, or this guy do that, or this kid do that. But nothing that's really going to affect the case. Nothing that's going to change the charges. Nothing that's going to affect the witnesses. Nothing that affects a target. Nothing like we talked before where it would be a maximum jail sentence or fine or the worst of the worst. We said it was a spectrum. It's a range. So with this type of a deal, it would have to be on the light, lower end of the range. That's one of two possibilities, completely inconsequential. That's why it was able to be done this quick. To fight, it's going to take a lot of time, a lot of money. You're going to, if a lawyer was talking to her saying, you're going to lose anyways, a lot of time, a lot of money. You don't want to do this. If you accept responsibility, we can get you a sweetheart deal. Let's just get this done now. If you fight it and it looks worse and gets worse, they're not going to give you the 2-level downward departure. You're going to get all sorts of problems, or the 2-level decrease. That's scenario 1. Scenario 2, which obviously, again, a lot of you that have been following cases and seen plea deals in the past, it's possible that she cooperated with the feds. She gave them information. She helped them out. She said somebody was asking me for this information, paying me for this information, forced me to tell them this information. So yes, I did commit a crime, but there were all sorts of reasons for it where it really wasn't my fault. And yes, I did it intentionally, and I knew that I was doing it and I still did it, but it was because of X, Y, and Z. That's a real possibility. But there are issues with that. Number 1, the timing. Usually, if you're cooperating with the feds, you're giving them information. They want to make sure it's good. They want to make sure it's solid. They want to make sure you're going to testify for them and it's going to be locked in and they're going to get those convictions or charges that they need you to get. So usually you don't get your plea deal. You don't get sentenced. They don't determine all of that until you're done cooperating. It's possible she's done cooperating. It's possible she was cooperating the whole time. She was a target of their investigation. They didn't file charges until they knew it was already going to be done. They filed charges. They got the plea deal done in a couple days, which I think included a weekend. And so maybe they're already done cooperating. And if that's the case, we should know more soon. We should know if there's any other criminal defendants involved. We should know if there are any other charges that are going to be filed. We should know if this goes deeper. And there are some things that would indicate that's possible, right? Because there were a lot of people, and I'll say on both sides, that knew a lot about the federal charges, the federal investigation, the grand jury proceedings in the federal process, right? There's multiple grand jury proceedings, state and federal level. But a lot of people were really confident, and it was unusual. Me and my dad talked about it all the time. Like, the feds don't usually do this or that. Why are they so confident? How do they know? Who are they talking to? Some of it was on the record. Some of it was in sidebar. Some of it was conversations we could hear. Some of it was conversations we couldn't. And again, if it was lawyers or law enforcement pressuring this grand juror, paying them, enlisting them to do their dirty work, this could get much, much bigger. We could learn a lot more. Was this a bump to see? Would anybody, where they were investigating the investigation, would they try to get a hold of a grand juror, get them to talk? Was it a bait to people involved? Those are all questions I've gotten from you. And the truth is, I don't know. Nothing in this so far would indicate it. It's possible we get more details about what exactly she revealed. Probably not if it's still sealed information, obviously. But this does leave the door wide open for people to speculate about, could this be connected to Karen Read? Is there more to come? Now, we're going to keep reading what else is in this plea agreement, and I'll tell you which of those two scenarios I think is more plausible, or where I would fall if I had to guess. Waiver of appellate rights and challenges to conviction or sentence. The defendant has the right to challenge the defendant's conviction and sentence on direct appeal. This means the defendant has the right to ask a higher court to look at what happened in this case, and if the appeals court finds that the trial court or the parties made certain mistakes, overturn the defendant's conviction or sentence. Also, in some instances, the defendant has a right to file a separate civil lawsuit claiming that serious mistakes were made in this case, that the defendant's conviction or sentence should be overturned. The defendant understands that the defendant has these rights, but now agrees to give them up. Specifically, the defendant agrees that the defendant will not challenge the defendant's conviction on direct appeal or in any other proceeding, including a separate civil lawsuit. And the defendant will not challenge the defendant's sentence, including any court orders relating to forfeiture, restitution, fines, or supervised release on direct appeal or any other proceeding, including in separate civil lawsuits. The U.S. attorney agrees not to appeal the imposition of the sentence agreed to by the parties in paragraph 5. The defendant understands that by agreeing to the above, the defendant is agreeing the defense conviction and sentence will be final when the court issues a written judgment after the sentence hearing in this case. That is, after the court issues a written judgment, the defendant will lose the right to appeal or otherwise challenge the defendant's conviction and sentence, regardless of whether the defendant later changes the defendant's mind or finds new information that would have led the defendant not to agree to give up these rights in the first place. In some plea agreements, this matters a lot more than others. In this one, it's such a good deal. I can't imagine if this person actually did these acts that they're charged with, why you would ever want to battle this good of a plea deal. The defendant is agreeing to give up these rights in exchange for concessions the U.S. attorney is making in this agreement. The parties agree. It's a quid pro quo, right? It's not a harsh sentence because you're willing to waive these rights and agree and take responsibility. The parties agree that despite giving up these rights, the defendant keeps the right to later claim the defendant's lawyer rendered ineffective assistance of counsel, or that the prosecutor or a member of law enforcement involved in the case engaged in misconduct serious enough to entitle the defendant to have the defendant's conviction or sentence overturned. So that still exists. They can still do that. Again, I wouldn't expect that because of the deal they've gotten here. Civil liability. This plea agreement does not affect any civil liability, including any tax liability the defendant has incurred or may later incur due to defendant's criminal conduct and guilty plea to the charges specified in paragraph 1 of this agreement. So they can still get sued based on this criminal conduct. That's obvious. We know that. Two separate jurisdictions, two separate parallel lines. Sometimes when there's a criminal case and a civil case, we say one doesn't necessarily affect the other. Sometimes they can affect each other, and many times you can take a plea deal and you can say it's all over, but that doesn't necessarily mean the civil action is over. And sometimes it can really help somebody. Like if what she did damaged someone else, whether it be a potential target, whether it be a victim, they can absolutely sue her for certain damages under certain civil statutes. Breach of the plea agreement. The defendant understands that if the defendant breaches any provision of this agreement, violates any condition of the defendant's pretrial release, or commits any crime following the defendant's execution of this plea agreement, the defendant cannot rely upon such conduct to withdraw a defendant's guilty plea. So if they commit another crime, they can't say, actually, I don't want this supervised release now. It's going to be worse because I committed a crime. You can't renege based on those parameters. The defendant's conduct, however, would give the U.S. attorney the right to be released from the U.S. attorney's commitments under this agreement to pursue any charges that were or are to be dismissed under this indictment or agreement, and to use against defendant any of defendant's statements and any information or materials the defendant provided to the government during the investigation or prosecution of the defendant's case. So something I want to mention about that line. First off, if you commit another crime, the U.S. attorney can say, hold on, we're going to go for harsher penalties under this charge and other charges. That's number one. Number two, they can use any statements you make in these plea agreements agreeing that you did this, but also any statements you made on the record behind closed doors. And what might those statements or conversations be about? Well, materials the defendant provided to the government during the investigation or prosecution of the defendant's case, even if the parties had entered any earlier written or oral agreements or understandings about this issue. Meaning, if we say, okay, all this is between us, you're not going to use this against me, right? No, I'm not going to use this against you. Then you commit another crime. All the agreements you make with the U.S. Attorney's Office can be null and void and gone because you're agreeing not to commit other crimes. So you breach, then they can breach. Does that mean that they were having conversations and working together during this investigation or prosecution? Is there something bigger? Is there something more? This line would indicate that's possible. But I will also tell you, this line is pretty common in federal plea agreements like this, where you work together, you agree, you accept responsibility, and you work out a plea deal. So could this indicate there's more? Sure. Or it could just be standard language in a plea agreement. The defendant also understands that if the defendant breaches any provision of this agreement or engages in any of the aforementioned conduct, the defendant thereby waives any defenses based on the statute of limitations, constitutional protections against pre-indictment delay, and the Speedy Trial Act that the defendant otherwise may have had to any charges based on the conduct occurring before the date of this agreement. Who is bound with this plea agreement? The agreement is only between the defendant and the U.S. Attorney's Office of the District of Massachusetts. It does not bind the Attorney General of the United States or any other federal, state, or local prosecuting authorities. Modifications to the plea agreement. This agreement can be modified or supplemented only in a written memorandum signed by both parties or through the proceedings in open court. If this letter accurately reflects the agreement between the U.S. attorney and the defendant, please have the defendant sign the acknowledgement of the plea agreement below. Please also sign below as witness. Return the original of this letter to the assistant U.S. attorney and Peruti. Acknowledgement of the plea agreement. I have read this letter and discussed with my attorney. The letter accurately presents my agreement with the U.S. Attorney's Office for the District of Massachusetts. There are no unwritten agreements between me and the U.S. Attorney's Office, and no United States government official has made any unwritten promises or representations to me in connection with my guilty plea. I have received no prior offers to resolve this case. By the way, These are some statements because you see Jessica Leslie at the bottom signed it on 7/14/2025, which is even quicker that they worked it out, a day quicker than July 15th. July 14th, they had this done. So on the 11th is when the charges came down. The 14th, they had this done. But if she reneges or backs out or withdraws, these are the types of statements that can be used against her. I understand the crime I am pleading guilty to and the maximum penalties for that crime. I have discussed sentencing guidelines with my lawyer, and I understand the sentencing ranges that may apply. I am satisfied with the legal representation my lawyer has given me, and we have had enough time to meet and discuss my case. We have discussed the charge against me, possible defenses I might have, the terms of this agreement, and whether I should go to trial. I am entering into this agreement freely and voluntarily, and because I am in fact guilty of the offense. I believe this agreement is in my best interest. Okay, and then signed by the attorney. He says, I certify Jessica Leslie has read this agreement and that we have discussed what it means. I believe Jessica Leslie understands the agreement and is entering into it freely, voluntarily, and knowingly. I also certify that the U.S. attorney has not extended any other offers regarding a change of plea in this case. Okay, so that's the charge. That's the plea agreement. What do you guys think? What do you think about the timing of this agreement? I also think it's really interesting. We see all these other people having these repercussions and consequences, losing their jobs, getting fired, getting charges, taking plea deals, other charges stemming from this Karen Reed situation. And it's really interesting to see what the outcome was for Karen Reed, right? Seems like these are harsher penalties than Karen Reed even ended up with for her OUI conviction. Really interesting to think of everything that was done in that vortex and continues to happen. Will there be more is the big question connected to this or something else. But what do you think this is about? Do you think this is about the bigger federal investigation? Do you think this is a big deal? Do you think it's going to be inconsequential? Let me know in the comments. I understand why people think this is about Karen Reed. Because of some of the comments, especially made by some people involved in this case. Some of the hints, some of the guarantees, some of the conversations they say happened. Right now, we just don't know enough, and this should not be a surprise. I mentioned it off the top. From my perspective, I don't know what she revealed. I don't know what witnesses she was talking about, what case she was talking about, how big of an effect it had on anything. If it was a big deal and it happened to be with a target and she was talking to lawyers or law enforcement, I absolutely expect more charges, and I absolutely expect that she worked with the U.S. Attorney's Office because I think her penalties would have been much, much harsher than 1 day time served and 2 years of supervised release. So that would go together if that's what happened. But from my perspective, I have to guess it was something more inconsequential. That lines up more with the timeline, with the chart or with the penalties and with how all this happened. But I could be wrong, right? That's just an educated guess. That is something inconsequential, not a big deal. She told somebody she worked with, somebody in her family. She did it knowingly and willingly, knew she shouldn't have, but she just talked about it because she thought it was interesting or crazy or wild, wanted to talk to somebody about it, even though she shouldn't. It's a long period of time, right? If this is something that happened in 2022 and she talked about it in 2024, imagine that's pretty tough. Now, she absolutely still shouldn't do it, but I can understand why this deal was made by the government, because if it was, I'm not going to say an accident, right? Because she said it was willful. But if this was something that was inconsequential and did not really affect justice in the case and did not ruin the prosecution and didn't do anything like that, didn't ruin a case for a victim or take a victim's chance at justice, then I understand the penalties that she was given, because while we need this to be a deterrent and we need to file these charges and we need to make these people take plea deals so that other jurors and grand jurors don't violate their oath, don't violate a court order, don't commit these crimes, because it's very important to the process. We also don't want to be heavy-handed and overly punitive to people that are doing their civic duty, that basically volunteered for an unpaid juror position that can be called in to hear different cases and investigations and all this stuff over a 1.5 to 2 year, even longer period of time on certain grand juries. We don't want to be heavy-handed, or guess what? We can't really blame people for not wanting to be a part of it. It's like, sure, I'm going to do my civic duty. And then because I talked to my husband or a coworker about it, now I can go to prison. I don't want to take that chance. Get me out of here. Get me out. I want to go back to my job and my life. And I can totally understand that and sympathize with them for people that are in that position, which is why it's all about a balancing process. It is a case-by-case situation, and that's how they have to handle it. I hope we get more information. a lot of parts of the federal process can be secret, but sometimes you do get a lot more information. And I really hope that we do. But in the meantime, I want to know what you guys think. And let me know if there's something that follows up on it. A ton of you guys tagged me in this, DM'd me on this. So send that over to me if you guys find anything else about it. But it's really interesting to me that we keep getting information and things trickling out that could have to do with Karen Read and the aftermath of her trial and her case. I'm also interested if any of her lawyers or anybody involved comment on this. I haven't seen that yet, which again makes me think it's probably something inconsequential, probably something that doesn't have to do with the Karen Read case. Maybe they're working with I've heard all the theories that this could possibly be. I just would need more information to really jump in and say, absolutely, this has to do with Karen Read. The federal investigation is not over. They're going to reopen it. There are going to be more people involved. To me, this does not necessarily indicate that. But if that's where it's going, and this is a part of it, hey, we got a lot more to talk about. So make sure you guys let me know what you think and what your questions are in the comments, how you're doing. Miss hanging out with you guys. Hit that like button. Make sure you're subscribed if you haven't done that already. That's all I've got. So until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.